seats, and members of the audience would take their seats. I would like the clerk to please open the roll and remind the members of the committee that it's not a voice vote, it's a vote on your screen. All present, please vote aye.
You have a quorum, Madam Chair.
Thank you. I would like to welcome everybody to the committee meeting and appreciate everybody's attendance and tell the members of the committee that this is in some ways a do-over because many of these, in fact, all of the constitutional amendments that are before you are amendments that have been heard before. And in fact, we tried to have a meeting in the fall and we could not get a quorum. And what we had done is we had carried these over because they are not properly before us in a year that does not precede an election year. Because in order for something to appear on the ballot, it must be heard in a year preceding an election year. Then we have to have an election in which all members of the House and the Senate are up for election. And then they have to then come back before the legislative body and be voted on again. So many of these were carried over. We tried to have a meeting in the fall, and we didn't have the opportunity to do that. So we're doing it now in an early meeting in session. We have a very compact calendar. It is a short session, and so we're meeting now to try to move these bills along. Again, these are not new to this committee, and I would also like to acknowledge that the room is packed for the obvious reason that one bill that, again, ERA has been heard in this committee in Privileges and Elections before. It has passed out of this committee before, and the members who were here to speak on both sides when it came before this committee were very respectful, and I was very, very appreciative of that. And so I would like to just ask all of you who are in this room to please be respectful. I know that people get very excited when people testify, and there are comments made, but I would just like to recognize that this is, in fact, a formal committee meeting, and that shouts or any comments from the room, not from a speaker, are not permitted. So if you will please follow those rules, then you are welcome to be here, and we are very eager to hear from the people on each side. Because we have the State of the Commonwealth and other things are going to happen, and in fact have a long docket, the people on each side have agreed, which is customary, that we're going to limit the time for the presentation. So there will be the presentation of the bill or the amendment, and then there will be an opportunity for people who are supporters and people who are opponents of the amendment to speak, and each side will have 5 speakers, and they will be allowed 2 minutes each. So with that, we are going to take up the first amendment, and it's SJR 270 and 284, and there is a substitute. If you'd like to move the substitute.
Madam Chair, I request to move the substitute. Rolling.
Okay, so the motion's been made and properly seconded to move the substitute, and what we have is SJ 270 and SJ 284, and the motion would be then to roll that.
And both patrons be listed as chief co-patrons of that resolution.
Okay, so the substitute is going to be a substitute that is properly before us, and so we're going to move that substitute, which is substitute for Senate for SJR 284. So let's first adopt the substitute. All in favor of the substitute, will you please vote aye? Is it a voice vote or?
Roll it in, if you're going to roll it in voice vote, electronic vote.
Or just substitute first? So first we're going to take up the substitute. All in favor of adopting the substitute, please vote aye. Yeah, please vote aye.
Hit it.
Oh, okay, aye, it's a voice vote. Thank you. You'd think we'd never done this before. Okay, now, the second motion made by, any opposed? No. Okay, so that, the substitute has been adopted unanimously. The second motion was to roll SJR 270 into SJR 284. That was made and properly seconded. All in favor of rolling
That would be taking Senator Saslaw's bill, rolling it into Senator Sturdivant's bill, and listing them both as chief co-patrons.
Right. All in favor, please vote aye.
Ayes 13, no 0.
Okay, so now we have SJR 284 properly before us. Senator Sturdivant, welcome. Your mic, we may need you to speak. Okay, sorry.
How's that?
Good.
Thank you for considering this resolution today. As you know, before you is the Senate resolution to approve the ratification of the Equal Rights Amendment. And I know many members of this committee have heard this, this resolution presented before, but I would hope that the chair and the committee would allow me to elaborate a little bit, having spent considerable time studying this and thinking on it. I think it's important to start out from a little bit of historical perspective that the Equal Rights Amendment, in one form or another, has been around for about 100 years. I think a lot of folks consider it something that began in the 1970s, but it was actually conceived and developed by Alice Paul and other leaders of the women's suffrage movement in the early 20th century, right after the 19th Amendment was passed. And in fact, the first ERA was introduced to Congress in the early 1920s by the nephew of Susan B. Anthony, who was a congressman from Kansas at the time. And the language of the Equal Rights Amendment that is before you today is virtually verbatim to the 19th Amendment. It's modeled after the 19th Amendment, virtually verbatim. And the 19th Amendment, of course, was the amendment that gave women the right to vote. And I think it's important to compare the two textually. The 19th Amendment, which gave women the right to vote, specifically says, quote, "The rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex," end quote. The ERA, as I said, is very similar. It's 24 words. And it says, quote, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex," end quote. So we know both the 19th Amendment and the Equal Rights Amendment came out of the women's suffrage movement in the early 20th century. And as we all know, the ERA has continued to be debated and discussed over the last 100 years. The other thing I think is important for the committee to take into consideration and to note is that the goal of the Equal Rights Amendment, and that is equality between men and women, has been the law of the land for many years. And a lot of progress has in fact been made over the last several decades. Prohibitions on sex discrimination are already in federal and state law and in about half the states' constitutions, including Virginia's constitution, which has had an Equal Rights Amendment since the 1970s. So the question, of course, is why do we need this amendment and why do we need it now? And I think the answer is pretty simple to that question. Equality between men and women is a core and fundamental American value that we all agree on. No matter where you stand on the Equal Rights Amendment, equality between men and women is a core value we all agree on. But despite these protections that exist in federal and state law and in state constitutions and have existed there, we all know in the General Assembly that federal and state law and state constitutions can and do change, and they're changed pretty easily, as we see from session to session and year to year. But I think more importantly, the reason why it's appropriate and important to do this now is that depending on who you ask, some do not feel that the U.S. Constitution currently protects equality between men and women. And some of you may have seen it, but there is a famous Justice Scalia quote from 2010, 9 years ago, where he famously noted that the U.S. Constitution does not prohibit discrimination on the basis of sex. This was Justice Scalia's quote less than a decade ago. Quote, "Certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't," end quote. So that's why it's important that we include the protection of this American value in the U.S. Constitution, like the other American values that are preserved and protected there. It's a simple argument, and I think it's one that most of us understand. Now, in a little while, you will hear, obviously, opposition to the ERA. And I think what's important, again, to note is we all agree on that fundamental value in the Equal Rights Amendment that the government should treat men and women equally under the law. There is no question about that in my mind. But there nonetheless are two primary arguments against the ERA that I think are worthy of consideration. The first argument is that the ERA is not timely, that it can no longer be ratified. I want to offer a few points in response to that. First and foremost, this debate here is not happening in a vacuum. This issue is not just before this committee, not just before this General Assembly, not just a question in Virginia. Several other states have ratified this amendment in the last several years, and as far as I'm aware, neither Congress nor the courts have said that those states were wrong in ratifying the ERA when they did. Second, there are very smart and reasonable people on both sides who disagree over whether Congress has the constitutional authority in the first place to put a time limit on the ratification of a constitutional amendment, or whether a deadline for ratification can be extended after ratification. And then lastly, let's just say for a moment that, for the sake of argument, the time for ratification has expired and the ERA can no longer be ratified, and that this is just a symbolic vote on the equality between men and women. Let's say for the sake of argument that that is in fact the case. Then by all means, we should vote to support this Equal Rights Amendment, certainly on those grounds. The General Assembly is no stranger to symbolic votes. There's no reason why we could not do it in this case. The second argument with regard to the ERA is that it's a Trojan horse for lots of things other than treating men and women equally. And again, I think historical perspective here is important for the committee to consider. 100 years ago, the ERA was opposed as a Trojan horse that would result in women working outside the home, or that would result in women serving on juries, and for a whole host of other reasons. 40 years ago in the 1970s, the Equal Rights Amendment was opposed as a Trojan horse that would affect alimony and child custody and put women on equal footing with men in the workplace, among other reasons. Now the reasons are different, and that opposition remains. But again, this debate does not exist in a vacuum. As I mentioned earlier, women's equality is protected in large part in state and federal law and in state constitutions. And yet, despite having been the law of the land for several decades, the concerns that are being raised today about the Equal Rights Amendment haven't materialized. So I would ask you, as you're considering this legislation today, this resolution today, I know many of you have considered it before, I'd ask you to do something a little different as you consider it. I'd ask you to put yourselves in the shoes of the legislators who considered and ratified the Bill of Rights 200 years ago. In their time, freedom of speech, freedom of religion, freedom of assembly, the right to bear arms, the freedom from unreasonable searches and seizures, every one of them was a novel and extraordinarily expansive right for its time. And of course, there were those who opposed certain amendments at that time during the ratification of the Bill of Rights because of concern over how they would be interpreted and applied, or how they would be misinterpreted and misapplied. But those rights were and are fundamental American values worthy of protection from government interference. And they are now spelled out and protected in the Constitution. The exact same applies here in this case. The only difference is that equal treatment of men and women is not a novel or a new right. So the decision here, I would submit, should be easier to make. And then lastly, and I'll end on this, and would be happy to take questions. I asked you to consider this in your heart. We all, I truly believe, agree that equal treatment of men and women under the law is a fundamental American value. We all believe that. I would ask you to consider what other fundamental American value do we reject because of our concern about how some may interpret it. I can't think of one. The bottom line in closing is that when we stick to our core American principles, which includes treating people equally regardless of their immutable characteristics, we get it right every time. And I would respectfully submit to you that this is the time to do this and to pass the Equal Rights Amendment. I would respectfully request that you do.
Thank you, Senator Sturtevant. Senator Saslaw, he's a chief co-patron. He'd like to have an opportunity to speak.
This is not the first time I've heard this argument. And contrary to what some people may believe, I was not here when it came up 100 years ago. Okay?
That's not what I've been told.
I wasn't, trust me. But, you know, I've heard all the arguments, you know, when it came back again in the early 70s, it was proposed by Congress. I remember clearly one of the things right out front, one of the first arguments made, and I don't remember whether it was Strom Thurmond or somebody had said, you know, with this, it's going to change everything. There'll be women, they're going to have to admit women to the service academies. Well, starting in 1976, that's exactly what happened. And in fact, to show you how far we've come with women in the service, just last year, a young lady from Fairfax City High School, African American lady, was captain of the Corps of Cadets at West Point and is currently a Rhodes Scholar in England. Then when I got to the Senate in 1980, and I was there for that first vote on the floor in 1980, when Virgil Goode, the vote was 20-19 against it, and Virgil Goode declined to vote on it, claiming he had a conflict of interest in that he was married to a woman. I mean, this will give you an idea of what's come from some of the people, not all, but some of the people opposing this. But I remember Virgil Goode getting up and telling me how the world was going to change if I voted for the Equal Rights Amendment. He says there'll be women in combat. There'll be women flying these fighter planes. And by the way, there are women now in combat. The woman that ran for just this last election, Congresswoman from the Virginia Beach area, was an Annapolis graduate with a career as a Navy officer commanding a boat. Out in Arizona, you had a U.S. Senate race, Martha McSally, who was a Republican congresswoman. She lost. She's now in the U.S. Senate because she was appointed to fill the unexpired term of Senator McCain, the late Senator McCain. She was an F-16 pilot. And interestingly enough, when I ran into Virgil Goode, who had predicted all these calamities if I voted for the ERA, I told him, you know, when I saw him last in 2007, I said, you know, Virgil, you're quite a prophet. You told me, Senator Saslaw, if you vote for the ERA, there'll be women in combat. There'll be women flying these planes. And he went on with a litany of things. And I told him, I said, you were right. I voted for the ERA and all these things happened. But you know, here's the problem, and it's a serious one. As Senator Sturtevant pointed out, it's dealing with other legal issues. Currently, courts can treat gender discrimination a lot more leniently than they have to deal with race, color, creed, national origin, which is in the Constitution. And things can change, as Senator Sturtevant pointed out. Back in 2000, the U.S. Supreme Court struck down the Civil Remedies provision for the Violence Against Women Act. We need to, quite frankly, after 240 years, we need to write women into the U.S. Constitution. They've been out of it long enough. And we ought not to be having to hear this every single year. As far as whether it go past this extension, back I think in the late 1790s, they sent a constitutional amendment out dealing with the compensation of members of Congress. Well, it finally got ratified around the late 1990s, 200 years later, and it's now, I think, the 27th Amendment to the Constitution. So this, what you hear from time to time that that it's expired is sheer nonsense. And I think Congress can easily remedy that. And I'm not even quite sure that they have to. But anyway, like I said, I've been here through an awful lot of this. After 240 years, it's time we put women in the Constitution of this country. Thank you, Madam Chairman.
Thank you. Okay. For those who wish to speak in favor of SJR 284, would you please come forward? And you'll have 2 minutes each of the 5 of you. And if you'll please come forward and state your name, and if the clerk will begin the clock when they start speaking. Welcome.
Good afternoon. My name is Yvonne Lewis, and I reside in Virginia Beach, where I do volunteer public service to improve the lives of others. My address, I don't know if you need it, was 3904 South Plaza Trail. I am also the chairperson of the Virginia Social Action Task Force for the South Atlantic region of Delta Sigma Theta sorority. Equality opponents have warned that we should not grant women constitutional equality because we don't know the consequences of this action. However, the gender equality in our Virginia Constitution and in 23 other state constitutions has not brought about the end of the days. Equality opponents were warning us about, so we've gone through that. The same argument of unintended consequences has been made against ratifying the Bill of Rights. Americans today can't imagine our Constitution without these 10 amendments. Fear of the unknown has never stopped Americans from exploring new frontiers or trying to right wrongs. So I would like to talk about the consequences of not including the Equal Rights Amendment into our Constitution. For too long, gender discrimination has been accepted as business as usual. Women have fought case by incremental case to gain access to education, sports, and even their own bank accounts and fiduciary lines of credit. Although women comprise over half the population, they are still underrepresented in every leadership position in the nation. By diminishing women's opportunities, we have handicapped our nation. Brilliant women and their contributions have been ignored. Take the case of national security.
Ma'am, you're over by 20 seconds.
All right. Well, I guess in closing,
I apologize, but thank you for being respectful. I appreciate that. Thank you for being here. And before I start the clock on Jacob, I just have to say I couldn't believe it when I saw Jacob's name as somebody who was going to be here. He's from my beloved Shenandoah County. Jacob French, welcome.
Good afternoon. My name is Jacob French, like you said, and I'm from the beautiful Shenandoah County. I'm here to urge you to pass a resolution supporting Virginia's ratification of the Equal Rights Amendment. I am a proud Republican and currently am the Woodstock Republican Precinct Chairman. I, along with 69% of my fellow Republicans, support the ERA. It was in the party's platform for 40 years. In 1972, Congress approved the Equal Rights Amendment, a Republican Congress, and submitted it to the states for ratification. At the time, however, Congress limited states' ratification period to 7 years. 35 states ratified the Equal Rights Amendment almost immediately. In 1979, Congress extended the deadline to 1982. Last year, several key legislators urged and argued that the Equal Rights Amendment was no longer properly before the General Assembly because of the congressional deadline. These legislators were wrong. In a letter dated May 11th of 2018, Virginia's Attorney General Mark Herring wrote, "It is my opinion that the lapse of the ERA's original and extended ratification periods has not disempowered the General Assembly from passing or ratifying a resolution. The General Assembly should not shrink its duties, especially with the fake argument that Congress's action is preventing state action. Other attorneys agree that ratification resolutions may be considered in the State House despite the 1982 deadline. Most Virginians support the Equal Rights Amendment. A recent Watson Center poll showed that 81% of Virginia voters want the General Assembly to ratify the amendment. Virginia has the historic opportunity to be the 38th state. To ratify the Equal Rights Amendment, if there's one thing we really do well in Virginia, it is that we make a lot of history. Please support the ratification of this important amendment. Thank you.
Thank you for being here. Okay, please, in the audience.
Good afternoon.
Welcome.
My name is Liza Mickens, and I'm a proud Richmonder. I am honored to represent Virginians, to urge you to pass a resolution supporting Virginia's ratification of the Equal Rights Amendment. I am descended from a legacy of feminists, activists, and status quo shakers, whose causes are interwoven in the history of Virginia. My great-great-grandmother, Maggie Walker, was the first woman to found and charter a bank in America and is to this day the only African-American woman to run for statewide office in Virginia. She used her position of influence to raise awareness and enact change on a myriad of issues affecting the people of her time. I'm here to continue that legacy. Virginia has too often been on the wrong side of history, and this time around, we can change that. With regards to women's voting rights, Virginia did not ratify the 19th Amendment until 1952, a full 32 years after it had been the law of the land. Virginia was also late to ratify the 24th Amendment, which declared an end to poll taxes. Virginia instituted massive resistance to outlaw school desegregation after the 1954 Brown versus Board decision, with some parts of the state choosing to close schools rather than integrate. Virginia was on the sad side of history by outlawing interracial marriage until our law was finally struck down by the Supreme Court in 1967. Virginia spent millions of dollars to keep women out of VMI. It wasn't until 1997 that all Virginians were finally eligible to attend any state-funded school. Recently, this great nation swore in 117 women in both branches of Congress. These women took a vow to protect and fight for the people they serve without being fully protected by equal rights under the law. Women voted to make this happen. We will continue to vote so not one more generation will be raised to recite with liberty and justice for all without equality under the law. Thank you.
Thank you very much for being here. Good afternoon and welcome.
Good day, and thank you for the opportunity to speak. I am Stash Kowalski from Percival, Virginia. I am a registered independent, and I also just retired from 23 years service in the military. The U.S. military is not my argument, but rather my example today of why Virginia should ratify the ERA. There are those who say the military is no place for social experimentation, but the fact is the military has always been a place for social experimentation, racial integration in the mid-20th century, gender integration, sexual orientation integration. All those happened there before they happened en masse in the American civilian society, not without growing pains, but with success. Today, women have earned their way to nearly every aspect of the military. I have served under, over, and with many of them. It's time to give all American women, not just those in the military, the constitutional recognition for the equality they've earned. Also, I've heard that there's no point in passing the ERA because the contents are covered elsewhere in legalities. Even if this were true, Virginia should still ratify the ERA, because if you don't, you are disregarding and disenfranchising what could statistically be termed an overwhelming majority of Virginia voters who support this effort in polls. And no matter what your intent or your reason, the optic you would be conveying is that you don't support Virginia women gaining constitutional equality. Ratifying the ERA tells half your state's population that you respect them as equals, and it allows you to execute one of the charges placed upon you as leaders, and which I learned and practiced in over 20 years in the Air Force. And that is, while you must always lead your people from the front, at the same time, you have to stand behind them in full support. Thank you.
Thank you very much. Good afternoon and welcome.
Thank you. Good afternoon. My name is Patricia Wallace. I'm an attorney in Richmond. On behalf of VA Ratify ERA for the last year or so, I've been looking at legal issues surrounding the Equal Rights Amendment. I found all opposition wanting. The ERA will not legalize abortions. Abortions are already legal in the United States. More urgently, we cannot turn a blind eye to the phenomenon of miscarrying at work. The ERA will provide a basis for implementing effective protections for pregnant and postpartum women. Some say the ERA will hurt women with Social Security, alimony, child support, child custody. None of these laws have been sex-specific for decades. The Pentagon already recommended that women register for selective services. Some say courts will construe the ERA as imparting absolute rights. This is not true. Our most sacred fundamental right, freedom of expression, is limited. We cannot shout fire in a crowded room. Also, religious organizations have not lost their tax-exempt status for opposing same-sex marriage, another empty threat. Some worry about litigation. You could say the same about any legislation these days, but that does not justify inaction. Opponents fear mixing the sexes, hospital rooms, prisons, bathrooms, sports teams, as if we don't already mix the sexes or manage segregation to protect privacy rights. The ERA's purpose is to ensure that all people enjoy equal citizenship stature, not to destroy the beautiful differences among the sexes. Some fear Virginia Beach will be flooded by topless women. And I see I'm almost out of time, but as we know, the Supreme Court has not let the First Amendment stop them from upholding nudity statutes. Thank you.
Thank you for being here. Okay. Those who are in opposition, if you would please come forward. Anybody who would like to speak in opposition? Good afternoon and welcome.
Good afternoon, Madam Chair and members of the committee. My name is Amy McInerney, and I'm from Prince William County. And as a woman, a feminist, a professional, and the mother of young adult women, I am passionate about authentic equal rights under the law. And indeed, I would be bold and venture to say that all of us here in this room cherish equality and equal treatment under the law. However, I urge us to pause and ask, what does that word mean? Because if we are talking about an equality of sameness, which erases the difference between men and women, then we are headed in the wrong direction. And indeed, I rejoice, as I'm sure everyone in the room did, about the accomplishments of all the ladies that Senator Saslaw mentioned. I will just point out that each of them achieved their goals without the Equal Rights Amendment. This is why I have come to oppose the Equal Rights Amendment, and I urge you to do the same. I am also concerned that our Commonwealth, which gave America 8 presidents, which gave us constitutional architects of brilliance like George Mason and James Madison, could, on this historic day, so dishonor the Constitution by pretending that this moot amendment can be ratified. Virginia is being asked to make history by becoming the 38th and final state to ratify the ERA, but the ERA is DOA, and it has been since 1982. On October 4th, 1982, in the case of Now versus Idaho, the Supreme Court dismissed it as moot, stating the amendment has failed of adoption no matter what the resolution of the legal issues presented here, because the ERA has not received the required number of ratifications. It is bad precedent to ignore precedent. Please don't put Virginia on the wrong side of history. Please be aware that harm may flow from enacting this. A flurry of litigation could ensue, which would be costly and damaging to our state. Thank you.
Thank you. Thank you very much. Good afternoon and welcome.
Thank you. Madam Chair, members of the committee, my name is Jacqueline Hawkins and I am from the Chesapeake area. As a Black woman, I have deep concerns about the ERA's possible effects on my community. The ERA has abortion consequences and they will be felt even more profoundly among us. Black women have the highest abortion rate in the country. We represent 11% of the female population, but have 28% of the abortions. To those who say the ERA has nothing to do with abortion, consider that in several states that have ERAs in their state constitutions, a right to taxpayer-funded abortion has been firmly established. In New Mexico Right to Choose, NARAL et al. Versus Johnson, the New Mexico Supreme Court ordered the state to pay for Medicaid abortions because they could not differentiate between abortions and the medical necessary procedures sought by men. The Supreme Courts of Connecticut and Washington have reached similar decisions mandating taxpayer-funded abortion for their state ERAs. The ERA is dangerous to all of Virginia's reasonable protective laws, such as the Women's Right to Know law, parental consent, and partial birth abortion law. If passed, the courts could decide that any of these laws are an impediment to women's access to abortion and overturn them. The ERA is designed to enshrine abortion as a basic human right that women must have, and pro-life laws interfere with that. Unborn girls and boys, especially the children of my community, will be among the greatest victims if the Supreme Court were to allow this version of the ERA to be resurrected. If a new ERA with abortion-neutralizing language were offered, it might provide appropriate legal protections to states' rights to pass pro-life laws. It is not possible to add such an amendment to this version of the ERA. As a member of the Virginia Society for Human Life, we oppose passage of this pro-abortion version of the ERA. Please vote no.
Thank you for being here. Good afternoon and welcome.
Good afternoon. Madam Chair, members of the committee, good afternoon. My name is Kelly McGinn from Prince William County, and I'm grateful to be here today to address you as a wife, mother, and a graduate of the University of Virginia Law School. I'm here today because I oppose the ERA. It's ironic that on this opening day of the 400th session of the Western Hemisphere's first representative assembly, you're taking up a bill that would transfer your authority over some of the most important personal rights of Virginians, including marriage, divorce, family, property law, adoptions, abortions, schools, and sports, from our state to the federal government. Section 2 of the ERA states that the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Congress and the federal courts will thus decide, not the people of Virginia or any other state, what sexual discrimination is, and this will mean an avalanche of lawsuits disrupting the lives of women in our state and across the country, who will no longer be able to rely on existing common sense laws to protect them. The ERA may sound benign and symbolically important, but it failed in 1979 and ultimately in 1982 because people recognized its vague promises would not advance the cause of freedom and protection for women, and this is even more true today. Section 1 of the ERA does not even mention the word woman or women, referring only to equality of rights on account of sex, a term which enjoyed a common understanding in 1972, man or woman, but does not in 2019. Thus, it is inevitable that any person seeking to protect their rights under this amendment will need to seek the intervention of the courts and will not be able to rely on any laws that currently protect them as a man or a woman. It truly is a Full Employment for Lawyers Act. Lawyers around the nation will thank Virginia for all the new business. Laws drafted specifically with women in mind will take issue, we take for granted, will be in jeopardy. The ERA is unnecessary in 2019. It's not 1972. Women are protected by the 14th Amendment and a long list of federal laws. All these laws would be superseded by the ERA. The law as written is too extreme. Women deserve better. Please vote no on the ERA.
Thank you very much. No. Please be respectful. Good afternoon and welcome.
Madam Chair and members of the committee, my name is Tony Delancey, and I'm the State Director of Concerned Women for America for Virginia. And on behalf of over 500,000 women across this country, we ask you to oppose the Equal Rights Amendment. The ERA will actually end up hurting women in many ways. Here's how it impacts women in the military. I know we've talked about it, but here's a personal example. Senator Sass talked about West Point. Well, in the late 80s, I attended West Point. I graduated from the United States Military Academy with about 80 other women out of a class of 945. I commissioned that day as an officer in the Army, and I went on to lead men and women in a tactical intelligence unit. This was the privilege of a lifetime for a man or a woman, but my women classmates and I did not need the ERA to accomplish this. We volunteered and we competed, and we were able to serve based upon our individual strengths and our unique abilities. Women today, as we said, are accomplishing more than ever in the military, and they enjoy the right to volunteer and compete to do those remarkable things. As Senator Sass said, serve in the combat units if they make it. Passing ERA would actually change this. It would force equal representation of women in all combat roles. This would impact readiness. It would put people in roles for which they are ill-suited. If passed, a future war would require women to be drafted. Passing this is not the right thing to do. We already have equal rights. I'm an example. ERA hurts women and would indeed hurt our nation's armed services. Please vote no. The Concerned Women for America of Virginia, thank you.
Thank you very much. Good afternoon and welcome.
Good afternoon, Madam Chairman, members of the committee. My name is Colleen Holcomb. I'm an attorney from Yorktown, Virginia. I represent Eagle Forum and the Virginia Family Foundation. Now, today you've heard some of the troublesome aspects of the Equal Rights Amendment. And if the present political climate is demanding some legislative affirmation of women's equality, don't women deserve more? Don't women deserve better? The procedural issues absolutely do matter. As you've heard today, the ERA actually, it did expire on March 23rd, 1979. The deadline was purported to have been extended, but even the Carter administration and the Congress that passed the Equal Rights Amendment and purported to extend that deadline specifically said, and this is quoting from John Harmon, who was the Assistant Attorney General under President Carter, certainly if a time limit has expired before an intervening Congress has taken action to extend that limit, a strong argument can be made that the only constitutional means of reviving the proposed amendment would be to propose the amendment anew by a 2/3 vote of each house. That never happened. The deadline was extended on the basis of a voice vote. That was a constitutional fraud, and that's unfortunately what's attempting to be perpetrated today. Even at the time, Congresswoman Griffiths, who was one of the champion sponsors within Congress, stated, "I think it's perfectly proper to have the 7-year statute so that it should not be hanging over our heads forever." Here we are 40 years later. Senator Hartke, a supporter of the resolution, stated, "If there is such a delay beyond the 7 years, then we must begin the entire process over again." Don't women deserve to have something as important as equality considered within a contemporary time frame? I urge each member of the committee just to take a look at the Gallup poll's congressional approval rating over the past several years. It's a great day for Congress when their approval rating gets into the 20s, even into the teens some days, and it hasn't gotten above 30 since 2009. Is this really the body we want to empower to be the arbiters of equality?
Thank you very much. Please, let's be respectful. Okay, Senator Sturdivant or Senator Sasslaw, do either of you have any closing remarks?
No closing remarks in length, Madam Chair. I think, again, I would just note that a lot of the same arguments we hear against the Equal Rights Amendment could have and may have been made against freedom of speech, freedom of religion, the other freedoms that we hold dear and core fundamental American values. And again, the way I have tried to think about this is we don't refuse to do what is right because we are worried about how others may try to interpret it or misinterpret it. That's not what I teach my kids. That's not how I know all of us try to live our lives. And so I think, again, as I said previously, when we stick to those core principles, those fundamental American values, we get it right every time.
Okay, thank you. Senator Sasslaw.
Yeah, Just briefly, all these, a lot of the discussion you just heard, including the woman that was a graduate of West Point, keep in mind this, that these were predictions when that first was proposed that would never come to pass. And it came to pass as a result of people who pushed it and forced the issue. We didn't vote to integrate VMI. The U.S. Supreme Court ordered it. And we ought not to be in positions where the courts are consistently doing this. All of the arguments that I heard on all the calamities that would happen as a result of the passage of the ERA, I heard prior to when, and I was just a little kid, no, I wasn't 100 years old at the time, Tommy, that when Harry Truman integrated the military and the civil service, all these things, and prior to the Civil Rights Act, all these predictions that you heard, all the calamities that were going to exist, were predicted what would happen if we gave full equality to the African American community. It's nonsense. 240 years after the Constitution of this country was adopted, it's time to write women into full equality, and I would hope you would pass the Equal Rights Amendment to the full floor.
Okay, thank you. Please, members of the audience, I ask you to maintain your silence. And before we vote, I'd like to ask, are there any members of the committee who have any questions of the patron? Either patron.
Madam Chair, I don't have any questions.
Members of the committee who wish to make a comment?
Yeah, Madam Chair.
Senator Edwards.
Yes, thank you very much. And thank you all for being here. This year is the 400th anniversary of the founding of the House of Burgesses in 1619. It's an historic year in Virginia. Wouldn't it be great this year that Virginia would be the 38th state in the Union to pass the Equal Rights Amendment?
I would like to ask everybody, if you'd like to remain in the room, please, Senator Edwards, if you would just forbear for 1 minute. I would love to have everybody be able to remain in the room while the members of the committee make their comments and have their deliberation. It's very important to me. You came this far, you waited this long, and you sat here all day. I really, really want you to be able to remain in the room. But if you're going to be noisy, and I know it's hard, I know it's hard. I have a whole bunch of children at home. It's really hard to sit here all day and to be exuberant. And when you agree, I know it's hard not to show that you agree. But we won't be able to deliberate, and it's very difficult for Senator Edwards to say what he wants to say if there's a lot of background noise. So if you're going to be noisy, then we will have to dismiss the people who are in the room from the room so that the committee can deliberate. So again, if you want to stay, I'm going to have to insist that you not make any noise. Thank you very much. Okay, Senator Edwards.
Madam Chair, Virginia has not always been on the right side of history, but we have a chance to be on the right side of history this time, and I move the passage of the resolution.
Okay. Any others who wish to speak? Senator Eben.
Yeah, before that's,
On the mic.
before this the vote is taken, I had something I did want to say, which is, first off, there was some discussion about the length of time that could elapse between ratification and whether a deadline could pass by. And I wanted to point out that in Attorney General Mark Herring's opinion on this matter, that he quoted the Supreme Court in a case called Coleman versus Miller that said Congress, in controlling the promulgation of the adoption of a constitutional amendment, has the final determination of the question whether by lapse of time the proposal of the amendment had lost its vitality prior to the required ratification. In other words, that Congress solely could decide whether any lapse of time affects that. Now, additionally, a comment was made, I think, from one of the law school graduates here from Prince William, that this should not be decided by the federal government. We should not be ceding our authority to the federal government over enforcement of the amendment if it should pass. And I would just say that should we not have uniform laws guaranteed in every state, no matter where an American lives, in terms of abolishing slavery, equal protection under the law, or the right to vote? To me, the answer is yes, and I think this is a parallel. And just to echo Senator Edwards, I think it's time for us to be on the right side of history. So thank you, Madam Chair.
Senator Spruill and then Senator Cosgrove. Senator Spruill.
Thank you, Madam Chair. I've been reading and studying what everybody was saying, and I'm trying to find out what is the real reason I said, what is the real reason? Tell them before I finish, I'm tell you what the real reason, what I think it is. And you're going back to 1913, Women's March for have the rights. That was done by both black and whites, but it was white women that got to vote. And I'm questioning, what is the problem? What is men, particularly men who, older men that don't look like me? What's the problem? It's okay for a woman to be a doctor, be a lawyer, chief of police. You can run for president. So what, we can't have that. So what's the problem? And now let me be black a minute. And what I mean by it is this. I started having a flashback because I'm looking at what states that have not ratified this. And those of you who are older, you're 50, you'll catch on what I'm talking about. North Carolina, South Carolina, Virginia, Alabama, Florida, Georgia, Louisiana, and Mississippi. Now, some saying, it's just a black thing. Is that no, it's a male thing for some men who of a certain age who are not my color, certain age, because a lot of white men do support it, but those who are not, they're having a problem. And I said, Then we have someone was saying, well, during the slave time, some blacks wanted to stay with the master at that time because they were treated well. And that's fine, but we're talking about the overall for everybody. Not just because you were treated well. We're talking about everybody. Now, the Constitution, that Constitution was written, it wasn't meant for black folks. If that's the case, then why did it take the 15th Amendment, 1964, to give black folks the right to vote? You see? So we're talking about now, we're talking about this. In this day and time, 2019, women are still having the right, you can do everything. And I'm going to say to myself, what is the reason? The reason is, men shut your ears, because they are so afraid that women are more smarter than men. That's the reason. Let me just say it that way. So what's the reason then? They can take any excuse that you want. Dick Sasser has said as far as the armor thing, we do it, they do everything. So what's the reason? Everything you can imagine, they are doing it now. So what's the reason? It's time for us to get this thing passed right now. And it ain't our fault that you're more smarter than I am. I love you. So let's get this thing passed today. Thank you so much.
Madam Chairman. Can you, I've got a, okay. Let's hold on one second. Senator Howell had asked, and then I have Cosgrove, then Senator Dance, then Senator Chase. Okay, so Senator Howell.
Oh, thank you, Madam Chairman. One of the advantages of being up here on the podium is I can look out into the audience and see so many Virginians and others who are so engaged and interested in this topic. But I also see one of my heroes in life is sitting out there, and I just want to acknowledge that Ellie Schmiel is here. She's the founder of the Feminist Majority and has been fighting for this amendment since the 70s, so I'm really glad to see you. But usually, when we pass an amendment here, it's important to Virginia and Virginians. This amendment is important not only to Virginians, but to all Americans, because it will put us over the top. If we can get this through the General Assembly, we will put it over the top. And frankly, it is absolutely past time for this. I'm getting old. I want to see it happen. I want to see it happen soon. So let's move on with it.
Okay, Senator Cosgrove.
Yes.
Thank you, Madam Chairman. I have a question for either one of the patrons. Senator Sturtevant, Mary Baldwin University has the Virginia Women's Institute for Leadership, which was established when the Supreme Court, we were having problems with the VMI. Of course, VMI's single-sex admission policy is no longer with us. Will passage of this amendment ultimately jeopardize and eliminate the Virginia Women's Institute for Leadership, Mary Baldwin College?
Mary Baldwin. Madam Chair, it's a good question, Senator Cosgrove. I would ask, I don't know the answer to this, is Mary Baldwin public or private?
I believe it's a public school.
Okay.
It's a private school? It is a private school, okay.
Okay. So, Madam Chair, Senator Cosgrove,
that answers my
I think that hopefully answers the question. This is state government interference with discrimination on account of sex.
Gotcha. Thank you very much.
Sorry, Senator Dance, and then Senator Chase.
Thank you, Madam Chair. I'll be brief. I will say that I have had an honor of serving as one of the chief co-patrons on this bill with Senator Sturtevant, and it has been quite a journey and even a learning experience working with the men and women that believe that this is our time in Virginia. This is 2019, 400 years ago. Our ancestors, when I refer to this, I'm like Senator Sproul right now. African Americans came to this great Virginia, if you will, and it's 400 years later that we talk about this at a time when it should be easy to pass this. I know that you all that are here know that Senator Sturtevant did an excellent job. He really was a lawyer in chief as he presented the best case for us as far as why Equal Rights Amendment should be ratified here in Virginia this year, and irregardless if it was making us the 38th state, which is a wonderful thing because then we would have the right number. And the gentleman from Northern Virginia, and he'll get me because I don't give his right area, but Senator Saslaw gave us some history because he knows it. You know, it's good to have somebody to know where the bodies are buried and know all of that. And he provided all of that for us. We've heard both sides. And I think that both sides really realize that we need to, as women, because a lot of us are here as women, and we have children. And we have grandchildren and great-grandchildren. We have daughters, granddaughters, that we want them to look back on 2019 when we celebrated 400 years. We are the body, the oldest continuous body that have made laws for people. Let's shine in 2019 because we have an opportunity to show the rest of the country how it's done. Virginia is known as no matter what we disagree on, we most times are agreeable. Sometimes we shout a little bit, but we are agreeable people. We agree to disagree. But I think today should start the process where we agree that it's okay for women to have equal rights. We have proven that we can handle it very well. And I know all the men in this room, our colleagues in the legislature, know that we have handled it very well, and they trust us to a certain extent. I just hope enough of those wonderful men, because you think about it, over 100 years ago, it took men, and you were American men, Senator Sproul, they were, and they allowed women the right to vote. That's all we have in the Constitution, the right to vote. Now, I know as African Americans, we didn't get it until 1965, but women had the right to vote. And our founders, and I won't even talk about that Delta Sigma Theta Sorority Incorporated, that was there, that marched at the back of that line of women, of Euro-American women, because they believed it was the right thing. They didn't get to vote then. They put their lives on the line so that we could get to 2019 and become the 38th state to ratify this and make it happen. Senator Sturtevant, Senator Saslaw has given a good argument as to why this should happen, and I support it. Thank you.
Thank you, Senator Dance. Senator Chase.
Thank you, Madam Chairman. Just a quick question for either one of the patrons. On line 37, there's a reference to sex without any definition. I think one of my biggest concerns with this ERA amendment, and I will tell you, is that there is no definition of sex that's actually in the article, whether it's passed in another state or what have you. And that is my biggest concern, is how do you define the terminology of sex?
Yes, Senator Sturtevant, go ahead.
Madam Chair, Senator Chase, another good question. I would refer you to line 50, which is the language from the House Joint Resolution 208 from Congress that contains the Equal Rights Amendment. This is what was sent out to the states for ratification. And it says, quote, proposing an amendment to the Constitution of the United States relative to equal rights for men and women, period. Lines 50 and 51. And so that's how, I understand, I think that's how that is the legislative history of this amendment.
Do we have a copy? Mine only goes to line 44.
Madam Chair, Senator Chase, it'll be lines 28 and 29 of the substitute.
Okay, I don't have that in front of me. Let's see. Okay, here it is, right here. I have it. Okay, I still feel like in the actual article itself, there's very vague term about sex, and that has been a real concern for me, that we're not defining the terminology that we are using in this language. I'll tell you, first of all, I want to say I really appreciate all those that have come to my office for and against. I want to give a special shout out to Eileen Davis, who let me borrow her book, Equal Means Equal. And I actually spent last summer reading through that book. And so I've given this a great deal of thought. I have put together a team of former legislators who have actually read all of the public hearings back from the 70s and from the 60s. I've met with Ms. Davis several times. And can I just tell you, my concern is this: absolutely everyone is for, equal rights between men and women. Let's just make that very clear.
Madam Chairman.
The concern, let me finish. The concern here for me is that are women going to be treated identical to men? And I think that's where a lot of the issues are, especially in the day and time in which we live, where the definitions that were probably different 50 years ago are today. Those definitions are very different. So I have some concerns of how that definition would be applied. And so what I've done is I've listened to your concerns, and I've actually drafted an equal rights affirmation with several other folks who are much smarter at this than I am, and have put that forward. So I would ask those of you, my legislative colleagues, who we want to affirm women. We've come a long way, and there's so many of you in this room, many of my legislative friends sitting on the front row, who have lived through the days that I have not lived through. And I tell you, it is such an honor to be up here as a woman in the state Senate. We have a chairman of our committee who's a female. And you know, women have come a long way, to Senator Saslow's point, without the ERA amendment. What if we introduce something that would send a message that would change that progress that we have? So for that reason, I'm still very concerned about that. I appreciate the patrons bringing this. I know Senator Sturtevant, his heart is in the right place. And so sometimes we just have to agree to disagree on issues. And I appreciate the comment. Thank you.
Senator Chase, did you want Senator Sturtevant to respond to anything on that you said?
We're good.
No, okay. Senator Saslaw.
Yeah, about 100 years ago, it seems we passed the 19th Amendment to the Constitution, and I think it said that the right to vote won't be denied or abridged on the basis of sex, period. In the ensuing 100 years right up to today, I'm not aware of any problems that have occurred because they didn't put a definition in there of what constitutes sex. If it didn't affect the right to vote, I don't see where it's going to affect anything else. Thank you.
Okay. All right. I want to wrap this up because I know we still have a fairly significant docket, and we've only done one, and that's while we limited it to 2 minutes per speaker. So again, I do appreciate everybody who has tried to help us move this along. And if there are no other members of the committee who wish to speak,
Madam Chair, I want to second the motion that.
okay, because the motion has been made and now, thankfully, properly seconded. With that, then I would call for the vote. All those in favor of passing SJR 284, will you please vote aye on your screen?
Ayes 8, no 6.
Okay, SJR 284 passes. Thank you, Senator Sturtevant. Thank you, Senator Chase. Please. I would ask you all to please exit quietly and continue to be respectful because the committee is still in progress. Okay, the next bill that we have is SJR 251 and SJR 279.
You may want to take like a 2 or 3 minute recess or 5-minute recess. Use the restroom, get everybody to clear out.
Okay.
And that way it's not going to be disruptive to whoever's next.
Okay.
In my humble opinion. And Bryce's.
Okay. All right, we're going to take a small 2.5-minute recess till everybody sort of leave who wants to leave. Okay, we're going to try to move to the next SJR 251 and SJR 279. That's Senator Edwards and Senator Eben. I know we still have some people moving in and out of the room, but we are going to get short on time if we don't try to move on through the docket. Welcome, Senator Edwards.
Edwards. I sponsored SJR 279, Senator Evans, SJR 251. I'd move that my bill 279 be rolled into my resolution be rolled into SJR 251.
Okay,
with Senator Evans and Senator Edwards be
Okay, the motion's been made to roll in SJR 279 into Senator Evans' SJR 251. Motion's been made and properly seconded. All in favor, please signify by saying aye.
Aye. Into 250.
251.
No, 251 was right.
251, it's 251.
I apologize, I got the wrong one here.
Okay, sorry, I apologize. It's a recorded vote. I wasn't looking at my pink sheet.
And list them both as chief co-patrons.
Yes, and we're listing both as chief co-patrons. So it'll be SJR 251 will be the new bill it's rolled into. Please vote aye.
They proxied us.
Okay.
It's 14-0.
Okay, so now we have SJR 251 properly before us.
Okay, thank you, Madam Chair. What these bill is propose allowing the voter, beginning the process of considering allowing the voters to repeal the amendment from the Virginia Constitution that was adopted in 2006, the obsolete and unconstitutional amendment on same-gender marriage and civil union passed by the voters. Now, according to the U.S. Supreme Court in Obergefell versus Hodges in 2015, these prohibitions are no longer valid. Senator Edwards can tell you more about the Code Commission and the Attorney General's opinion, but they've agreed, and I should say the Code Commission has agreed unanimously, including with the support of, or with the vote of all the senators and delegates on the commission, Republican or Democrat. And people should be given the opportunity to see that the Virginia Constitution accurately reflects their values in federal law. We also, in my opinion, need to remove any legal ambiguity and confusion, having the Constitution reflect the law of the land. With that, I would note that further that in 1968, just 1 year after Loving versus Virginia, Virginia repealed its anti-miscegenation law, and same-gender couples today are allowed to do the things that other couples can do. So with that, I'll conclude my presentation and turn it over to Senator Edwards.
Senator Edwards.
Thank you, Madam Chair. My bill, SJR 279, now rolled into SJR 251, was referred originally by this committee to the Code Commission back in 2017 for the question as to looking into whether or not this was proper. The Code Commission in turn referred the matter to the Attorney General under his authority in the Code Commission to look at whether or not certain legislation is obsolete. We frequently recommend repealing obsolete legislation. The Attorney General on August 11th, 2017, sent a letter to me as chairman of the Code Commission advising that indeed the legislation banning same-sex marriage as well as the constitutional amendment banning same-sex marriage was indeed obsolete on the grounds that the United States Supreme Court in Obergefell versus Hodges in 2015 found legislation and statutes in other states outlawing same-sex marriage to be unconstitutional. And so based on that, the Code Commission on September the 28th, 2018, at least I wrote a letter dated September the 28th, 2018 to the Clerk of the Senate advising that Indeed, the Attorney General had said that this legislation is indeed obsolete. It was a unanimous decision by the Code Commission, and the Code Commission voted to recommend to the General Assembly that the constitutional amendment that we're dealing with here be repealed. And hence, Senate Joint Resolution 279 has been filed, and now it's been rolled into Senate Joint Resolution 251. I'll be glad to answer any questions.
Okay. Are there any members of the committee who have a question of either Senator Edwards or Senator Evan? Are there any members of the audience who wish to speak in favor of SJR 251? I'm going to start, and we're going to keep it to 2 minutes if that's okay. Thank you.
Chairwoman Vogel, members of the committee, good afternoon. My name is V. Lamnick, and I'm the Deputy Director of Equality Virginia. I'm here today to speak in support of Senator Evans and Senator Edwards' constitutional amendments. These amendments seek to repeal Virginia's constitutional amendment that was approved by referendum at the November 2006 election, banning same-sex marriage and civil unions. The 2006 amendment was ruled unconstitutional in 2014 in the case of Bostic v. Schaefer, and further invalidated by the United States Supreme Court in the case of Obergefell v. Hodges in 2015. However, the text of the 2006 amendment, though unenforceable, remains a part of the Virginia Constitution. Senator Evans and Senator Edwards' constitutional amendments simply ensure that the text of our Constitution reflect the reality of the law in this area. Also, I'd like to add that I have been authorized to say that the ACLU of Virginia also supports these amendments. We appreciate your support for the proposed amendment. Thank you.
Anybody else who wishes to speak in favor? Anybody wishes to speak in favor?
Yes, ma'am.
Good afternoon and welcome.
Good afternoon. Thank you. I'll be brief. I'm Scott Price. I'm with the Alliance for Progressive Virginia, and we support this legislation. It's time for Virginia to remove this antiquated section of the code. Thank you.
Okay. Anybody who wishes to speak in opposition? Good afternoon and welcome.
Good afternoon, Madam Chair, members of the committee. The issue of marriage is and always has and always will be a matter of profound importance for the many reasons that should be obvious to all of us. And this is no more or less true whether its definition is placed into a constitution or not. Nevertheless, the people of Virginia saw fit to affirm its definition within the state constitution, much like a majority of other states did as well. And yet, we all understand that the U.S. Supreme Court's 2015 opinion has effectively invalidated those. As it stands, this constitutional clause is no longer recognized. Meanwhile, as the overruled amendment language still technically remains, no one is being harmed by its presence, and no one is confused as to its legal effect. There is no apparent need for its formal removal, and a symbolic campaign to scrub it from the record by putting this extremely sensitive issue back onto the ballot when the outcome either way would change absolutely nothing, could only serve to confuse the voters, but worse, it will most certainly rip wide open deep cultural wounds. This would not promote the common good of our Commonwealth, quite the opposite. To date, no one state has removed its definition of marriage from its constitution. Perhaps this is because there is simply no need. Perhaps they realize how harmful and unwise it would be to stir up bitter controversy where there otherwise is none. And perhaps they've had much more pressing things to do, things that will actually move the needle on the issues that affect the lives of their citizens. Putting this on the ballot would only be stirring the pot of acrimony and strife for its own sake. I think we can all agree that we've got enough of that already. We urge you not to put Virginians through any more of it through this effort. Thank you.
May I use his unexpired time? Well,
Yes, you may.
thank you.
I don't know how much he's got, but go ahead.
Madam Chair, my name is Robert Marshall. I was the House author of the Virginia Marriage Amendment, which voters approved in 2006. I want to read to you from an opinion from Homer Cummings. Who's Homer Cummings? He was the Attorney General appointed by Franklin Roosevelt. And this is an opinion he gave on April 3rd, 1937. In answer to your question of April 2nd, 1937, for my opinion respecting the present status of the District of Columbia minimum wage law in view of the recent decision of the Supreme Court in the case of West Coast Hotel versus Parrish, overruling the case of Adkins versus Children's Hospital, I have the honor to advise you as follows. The District of Columbia minimum wage law was approved and became effective on September 19, 1918. The act provided for the administration of a minimum wage board to be appointed by the commissioners of the District of Columbia. It provided for the organization of the board and defined its powers and duties. The board appointed under the statute, acting in pursuance thereof, issued its order prohibiting the employment in the District of Columbia of women, of minor girls, of certain industries of less than a prescribed wage per month. Children's Hospital sought to enjoin the board from enforcing its order against the hospital. An injunction was issued by the Supreme Court in the case of Adkins versus Children's Hospital, decided April 9, 1923, on the grounds the statute was unconstitutional. The effect of that decision was to suspend further enforcement of the act. In the case of West Coast Hotel versus Parrish, Supra, the Supreme Court said our conclusion in the case of Adkins versus Children's Hospital should be and is overruled. The decisions are practically in accord with the courts having no power to abolish a statute, and that notwithstanding a decision holding it unconstitutional, a statute continues to remain on the books, and that statute be declared unconstitutional, and the decision so declaring be subsequently overruled, the statute will then be held valid from the date it became effective. It is therefore my opinion that the District of Columbia minimum wage law is now a valid act for the Congress and may be administered. I just want to call to your attention that the Library of Congress has compiled a list of cases in which the Supreme Court has reversed itself from yes to no or no to yes from 1791. 234 of these was the last count that I saw in the summer of 2014. There's no need to take this off the books, and in fact, Gerald Nadler, who's the chairman of the House Judiciary Committee, is nervous that Trump appointees are going to reverse a bunch of these decisions, including the marriage decision. So he's going to hold hearings on this. So I urge you not to remove this from the statute books.
Thank you. Good afternoon and welcome.
Thank you, Madam Chair, members of the committee. Jeff Caruso with the Virginia Catholic Conference. Marriage between a man and a woman is the human and social institution upon which civilization has been structured since the very beginning, across times, places, and cultures. Marriage has an original design and purpose that predates any nation, religion, or law. A core duty of government is to preserve this institution and pass it on to future generations. Given current law, it is true that the provision in Virginia's Constitution that marriage is exclusively the union of a man and a woman is not in effect at this point. Right now, it is a dormant provision. It is also true that Supreme Courts change and federal laws change. So a state law that is dormant now would become effective again if the federal law changes, but only if the state law remains on the books. The decision before you today, therefore, should be based on what you believe is the right policy for Virginia. If you believe, as we do, that marriage is and can only ever be the union of one man and one woman, please vote to continue reflecting that in our state constitution. Thank you.
Thank you. Good afternoon and welcome.
Thank you for letting me be here. My name is Zach Bennett. I'm pastor Salem Baptist Church in Goochland County, and I am in favor of keeping the marriage amendment exactly the way it is. As I heard a lot of the arguments from both Senator Sturdivant and some of the other senators about the ERA amendment that you just voted on, it was very clearly that even though there had been much incredible advantage taken over the last 40 years, that it was still at least a symbolic gesture that you voted for it. I don't know if you listened and voted that way according to Senator Sturdivant, but with the same meaning, it's very clear that the people of Virginia have spoken clearly in 2006, and the majority of Virginians still define marriage as between one man and one woman. And so I would encourage you to continue to leave the marriage amendment exactly the way it is, and not let the fact that the federal government has made a statement to impact Virginia in this way at this time. And I encourage you to vote against this marriage amendment. Thank you.
Are there any members of the committee who have a question to the patron? I have a question. I'd like to ask a question to one of the speakers who spoke in opposition. If one of them would mind coming back, maybe the pastor who just spoke so eloquently. I just would like to pose this question. I understand the comments that you made about this being a symbolic vote, and I'd like to ask you this question, because what it is that the patrons of this constitutional amendment resolution are actually putting forward are not actually a repeal, but the question of putting it to the voters again. And so, as I see this, we had an issue that was put to the voters. We've had an intervening United States Supreme Court decision. We would then, have the opportunity for this to again go to the voters. And so my question is, I personally don't find it objectionable to have this go back to the voters again, because we're simply saying, you, the voters in the Commonwealth of Virginia, have the opportunity to be heard. And it's not inconceivable that they could vote the same way again. And so I guess I would ask you that question, because in my view, I see that very differently, that they would have the right and certainly the exercise, the opportunity to have the communities, the faith community and any community, come forward and encourage people to go vote. And so I would just ask you, do you in any way in your own mind separate the issue from the opportunity to have this go on the ballot again? I guess that's my question.
Right, and I understand. I mean, in 2006, it was clear. It was a better majority than just 51%. And so putting it back before the voters, I understand very well. I guess I referred to the first speaker that was here who said, is this the right time to do that? And I guess that is my concern, is that in the very difficult and strenuous situation that we find ourselves in, the discord, even though I extremely was in favor of the theme of the prayer breakfast this morning for civility, I would just say that this year is not the year. Maybe there will be a time to put it to the voters again. I guess I would let it last a little more than just 12 or 13 years, though, the marriage amendment. From my vantage point, I'm a pastor, I'm a Christian. I believe that the Bible is the truth, and therefore it's real clear to me that it doesn't really matter what the Supreme Court says. I know what God has said for 6,000 years in all of human history. And so no matter what the vote is of even the Commonwealth, I would always stand for marriage between one man and one woman, like all three main monotheistic religions is. But I would just think it's not the proper time to allow this to go back to the voters.
Okay, thank you. I just wanted to ask that question. Senator Edwards, I have a question for you. One of the issues is I've had discussions with others about one of the criticisms that is often leveled at me and perhaps how I manage my committee is that there's only a limited amount of space on any ballot in any given election for how many questions that we allow to go on the ballot. And when the Code Commission makes the recommendation, that's obviously not part of the consideration. So the question I would pose to you is, when the Code Commission makes you as chair of the Code Commission, you have this debate. The Code Commission's underlying substantive rationale for why it is that something has to be addressed is because it's obsolete, correct?
Correct.
That's the underlying issue.
That's correct.
It's not a consideration of whether or not it's practical to have it be on the ballot along with however many other issues, correct?
That's correct.
Okay. All right. Is there any member of the committee who wishes to ask a question of either of the patrons? Is there any other discussion?
In summary, could I just?
Yes. Do you have any final closing remarks?
Yes, I do. This does not affect anybody's religion. Religions have different views, and they're entitled to practice their religion as they wish. And so this would not affect anybody's religious beliefs or religious practices. As I said, the Code Commission asked the Attorney General as to whether or not this is obsolete. Because one of the things we look at is legislation obsolete? And the Attorney General made it very clear, yes, it is obsolete, and unanimously, the Code Commission said we should recommend both the constitutional amendment as well as the legislation that would be coming forth as well, on the grounds that it was obsolete. I don't think anybody questions that.
Let me ask you another question. That was a unanimous
It was.
decision of Republicans and Democrats,
Exactly.
his recommendation.
I think I'm the only Democrat on the Code Commission.
Okay.
Yeah, that included Senator McDougal, Delegate Lefwich, former Delegate Habib, as well as Senator Edwards. I'm not sure if there are other legislative members. But the last speaker who spoke said he didn't think this was the right time. This is 14 years after the original amendment was adopted. And I think in addition to the fact that the Supreme Court made this ruling, we also have the fact that polling shows that a majority of Virginians do want to revisit that. So it may well have a different result. It might have the same result. But I think it's pretty clear that people of Virginia would like to have the opportunity to weigh in again.
Okay. All right. Well, I understand, and I certainly never have an objection to putting something back on the ballot. Senator Cosgrove, I apologize.
That's quite all right. Senator Ebbin, if it goes back to the ballot and it's reaffirmed, what are you going to do then?
Well, nothing. I mean, it would stay in the Constitution, and I would imagine that it's expensive to wage a campaign for a constitutional amendment. If it were to, a constitutional amendment were to fail, I wouldn't recommend that it be brought up here every year. I would, however, think it should eventually be brought up. Virginia has a history of being slow on some things and quicker on others. I think I don't have the stats with me. The constitutional amendment ratifying the right of African Americans to vote.
The message, yeah, in 1967, in Loving versus Virginia, the United States Supreme Court overturned Virginia's law on miscegenation laws. And this General Assembly abolished that statute several years later, within about 5 years, I think.
But there was other constitutional amendments, federal, that were not affirmed by the Supreme Court, by the Commonwealth of Virginia until quite later. And I just think we should give the people the right to decide now. If not 14 years, at what, I would reverse the question, say, well, what year would be right? Do we want to wait 25 years, 50 years, 100 years? I think 14 years is long enough.
Thank you.
Okay. Anybody else? I have nobody else on my sheet. Senator
Madam
Cosgrove was the
Chair.
only. Yes, Senator Howell.
I just wanted to move to report.
Okay. The motion's been made and seconded to report. All those in favor, please signify by saying aye, voting aye.
Ayes 7, nays 7.
Okay, the bill fails. Okay, next on our agenda is, I think Senator, and we don't have a sign up, but is anybody here? Who? Senator Lucas. Oh my gosh, sorry, Senator Lucas, I didn't see you. Because Hobie's giant head is right in my line of sight. So I couldn't see Senator Locke or Senator Lucas. I apologize. Yes, would you please lower your chair? Mm-hmm. Now I can see Senator Locke and Senator Lucas. Okay, so your two are identical.
Madam Chair, members of the committee. Senator Locke has SJR 261 and I have SJR 262, so I will yield to her.
I will let you guys decide whose gets rolled into whom.
Madam Chair, I would make the motion to roll one of the bills into the other. Who wants the bill?
It don't matter.
Well, you guys choose. You don't want us to choose. Lowest number?
Okay.
Madam Chair, I would make the motion that we roll Senate Joint Resolution 262 by Senator Lucas into Senate Joint Resolution 261 by Senator Locke and make them both chief co-patrons.
Okay, the motion's been made and properly seconded. All in favor, please vote aye.
Doesn't mean you have to sit down.
Okay. Well, now that it's been rolled into yours, she thinks her work is done. You can do what Senator Sasswell did, and there's a chair right there. You can lean way back.
Just don't call me Sass and take off.
I'm going to call you Sass.
Take off the S and that's
That's right. You can lean way back. There you go.
Thank you,
Okay,
Madam Chair.
welcome.
Thank you very
I'm
much.
sorry you have to put up with all this.
And members of the committee, thank you very much. SJR 261 and 262 will put before the voters a proposal to amend our Virginia Constitution to establish true universal suffrage for the first time in our Commonwealth's history. It would offer Virginia voters the opportunity to vote to repeal the Jim Crow felony disenfranchisement provision that currently stains our Constitution and guarantee a right to vote to all Virginians 18 and over that cannot be abridged by law. Voting is the cornerstone of our democracy. So much so, the right to vote is mentioned more times than any other right in the U.S. Constitution. Yet there is no explicitly affirmative right to vote provision in either federal or Virginia Constitution. Courts and legislatures do not always treat the vote as a fundamental right when deciding cases or passing laws, especially for citizens most directly impacted. It is time we made clear that the vote is inherent to citizenship, the essential building block of civic life in our democracy, and it belongs to the people, not the government they elect. Like our fundamental rights that never disappear, the right to vote should be guaranteed without exception. No person should be denied the fundamental right to vote. It is no longer okay to allow government to decide who gets to vote. Every citizen in Virginia, including those incarcerated, are governed by the same laws. If every citizen is governed by the same laws, it stands to reason that everyone must have the right to vote in choosing who represents them. When the government denies the right to vote to anyone, it tells them they are lesser Americans and indeed lesser humans. When people are told they are less than full citizen, it hinders rehabilitation, which is counterintuitive to the goals of the criminal justice system. If we want to rehabilitate people convicted of crimes, most of whom return to their communities to be safe and productive citizens, we should encourage civic participation while incarcerated and after release. A key component of a prisoner's rehabilitation in becoming a productive citizen is casting a ballot, the most basic building block in a democratic society. In Virginia, our current policies of felon disenfranchisement and no parole, coupled with the admitted and documented racial disparities at all levels of our criminal justice system, from arrest through prosecution and sentencing, have left 1 in 5 African Americans without the right to vote. And even after Governor McAuliffe's efforts to restore voting rights to everyone who has completed their sentences, hundreds of thousands of Virginians, most of whom are no longer incarcerated, and a majority of whom are Black, still cannot vote. And according to the Virginia State Police report on crimes in Virginia, 12,000 more people were disenfranchised last year. Voting in America is an entitlement, not a privilege. The right to vote is fundamental to our democracy, and it must be treated as irrevocable. The right to vote ought to be treated with the same respect as other fundamental rights in our democracy, such as freedom of religion or speech. The act of voting is perhaps the most politically expressive activity that any one individual can do in our democracy, to have their voice heard to who best represents them in government. That is why I have introduced SJR 261 and Senator Lucas introduced SJR 262 that will ensure that all qualified individuals who reside in Virginia who are U.S. citizens and who are at least 18 years of age have the fundamental right to vote. The voters of Virginia should have the opportunity to vote on this fundamental and simple proposition without further delay. Passing this resolution this year means that they would have the opportunity to vote on the proposed amendment in 2020. Not passing the resolution this year would delay the opportunity for the voters to have their say until 2022. In Florida this year, 1.4 million people had their voting rights restored at the ballot box. Because we don't have initiative and referendum in Virginia, this committee can choose whether to give Virginia voters a voice in the framing of the Constitution or not. Choosing not to pass a resolution this year is choosing not to give voters their say. I ask you to say yes on SJR 261.
Okay, thank you. Senator Lucas, do you want to add anything? It's already all been said. She did. Is there anybody in the audience who wishes to speak in favor of the bill?
Madam Chair, members of the committee, Claire Guthrie Gustiniaga, on behalf of the 25,000 members of the ACLU of Virginia, we are strongly supportive of establishing a right to vote in the Virginia Constitution. I think people, we listened earlier to the conversations about the Equal Rights Amendment, and we talked about the fact that the Women's Suffrage Amendment wasn't ratified in Virginia until the 50s, when it was passed obviously much earlier. But the reality is that there isn't anything in our Virginia Constitution that guarantees to every Virginian the right to vote, and there should be. The right to vote is the essential currency of democracy. It belongs in our wallets, and government should not be able to pick our pockets and take that right away from us or leverage it or mortgage it or condition it in any way. It's really time to recognize, as the senator said, that the right to vote belongs to the people and not to the people they elect. And so it's time to say once and for all that if you're over 18 and you're a citizen and you live in the Commonwealth of Virginia and you register to vote, you should be able to vote, period. You should have a right that cannot be abridged by law. And it is important to remember that voters have never had the opportunity to express their point of view on this, and it's time to give them that chance. In Florida, as the senator mentioned, an overwhelming majority of Floridians agreed to give 1.4 million people back their right to vote in this past election cycle. That leaves Virginia, Kentucky, and Iowa as the only states left in which you have a lifetime ban of voting if you get convicted of a felony, any felony, including stealing a $5 chicken. So it is critically important at this time for us, again, to look at ourselves in the context of history and to move forward and recognize that the right to vote belongs to the people and not to the people who govern them. And we strongly urge you to support this amendment.
Thank you. Good afternoon and welcome.
Good afternoon, Madam Chairman, Senators. Carol Nagle with the League of Women Voters of Virginia. And our National League principle states, the League of Women Voters believes that every citizen should be protected in the right to vote. As simple as that. And so we in Virginia support this amendment and agree with the comments that you have just heard. Many of us go to the jails and talk to those who do not have a right to vote. And when they find out that there might be a way to do that, it makes a difference in their posture and in their attitude and their belief that they could go forward. So we know this is universal right to vote, but we know those who are waiting to have that right. So we feel that right now, we know there's only one person who gives those rights back to vote, and that's the governor. And so why should it be one person or 14 people on this committee? We support the idea of giving that opportunity to decide to the people, let them decide on that and get that on the ballot next year.
Thank you. Good afternoon. Welcome.
Good afternoon, Madam Chairman and members of the committee. My name is Asadiq Abdul Rahman. I speak on behalf of New Virginia Majority, a statewide organization committed to building power in the urban question of Virginia, from D.C. to Virginia Beach. I speak in favor of the Senators Lucas and Locke's bill. When Governor McAuliffe restored my rights. But first, let me mention this. Did you know that this is the year that celebrates the 400-year anniversary of the House of Burgesses? Considered to be the first democratic elected assembly body in the United States. But only planters, only those who own land could vote. So it wasn't a democracy. It wasn't a consistent democracy. It wasn't. Fast forward to right now, Virginia is still not a consistent democracy. When Governor McAuliffe restored my rights to vote, I was incredulous. I had to Google it to find it out because I didn't believe it when people told me that Saturday afternoon. And I registered on the State Department of Elections website, and I went out and I registered over 500 ex-offenders, and they wanted to vote. They wanted to participate in our democracy. We pay taxes, not the taxes that people talk about that the rich pay, we pay the real taxes, tolls, restaurant taxes. We pay most of the taxes, but we have no representation. We can't punish our legislatures for not representing us because Virginia is still not a consistent democracy, and it's an outlier. It is behind the curve. Thank you, Madam Chairman. Thank you, Senator Locke, Senator Lucas.
Thank you. You're a great public speaker.
My ex-wife doesn't think so.
Yeah, I'm not sure I would want to be in her shoes. Yeah, your poor wife. She's not going to win a lot of fights at home. Good afternoon and welcome.
Good evening, Chairman, Commissioner. My name is Wayne Keaton. On my behalf, I'm going to tell you a little bit about my story that I was incarcerated in 2010, and I for possession of substance. And by the grace of God, our former governor gave my rights back in September 2016, because I've been fighting from 2010 to now. What surprised me that when my anniversary is coming up February 7th, 2019, I will be celebrating 9 years of sobriety. I came home and see my wife. I asked my wife why she's smiling for. She told me, I got an envelope for you. I opened the envelope, and it was papers, restored my rights back. When in my life, I live and suffer with a lot of things, but I am in my joyful of recovering. Community service, whereas I got community service because I give back to society what was given to me. I'm the senior director of Richmond Drug Court. I'm the chairman of Alcoholics Anonymous. I'm the leader of the security board at my church. I go down to the jail and bring recovery inside the walls. For me to act, men and women is incarcerated. From my heart, I think they should have their rights back to vote because we need it.
Thank you.
Everybody needs to go out to vote to make this world better. Thank you.
Thank you very much for being here.
Good evening to you all.
Good afternoon. Thank you for being here.
I'm here to support the bill SJ 261. I'm from the New Virginia Majority Group. My name is Robert Davis. Just to give you a little background on myself and how it felt to not to have my rights. I never understood the importance of voting. I lost my rights when I was 18. I always wanted to vote. I can always remember when people asked me, did you vote today? And I'd be like, I just look at them and stare and walk away, because I never had that right to vote, And you know, being a citizen, a U.S. citizen, and I was able to work and pay my taxes and walk around on this U.S. soil, but my rights were stripped away because I was a felon. And yes, I'm still a felon. And I still walk around with a number over my head, still in chain. My number is 16050, you know, and I support this bill because I think it's very unfair. You know what I'm saying? Everybody should have the right to vote, you know, and I just hope it passes, you know. I'm 50 years old today. It took me 30 years. My first time voting was in 2016. In 2016, that was my first time ever voting because my rights was taken away. But today, I'm overjoyful because I can vote today. It feels good to vote. I have a voice today. And I thank y'all. Thank you.
Thank you for being here. Is that 5?
Good afternoon.
Okay. Good afternoon. Welcome. Thank you for being here.
Thank you for having me. As a private citizen, as a mother, as a grandmother, I haven't prepared a speech. I'm not going to tell you what everybody else has been telling you. I'm going to tell you what I've witnessed. I've been out there. I've registered hundreds of people that has had their rights taken away from them. Some 50 years ago. Is that fair to them? One man stole a chicken because he didn't have anything to feed his children. So I thought it was ironic when Muhammad said a $5 chicken. He caught a felony charge 50 years ago and has not had the right to vote until this year when I registered him. He cried when he got his rights back. So I'm telling you what I witnessed. One lady, her brothers were members of a drug gang, had nothing to do with her. She was riding with someone. They had marijuana on them. She caught a felony. Wasn't even on her, but she caught a felony. She wasn't able to vote. She hasn't voted in 18 years. I did her restorations. She's now able to vote. But this was nothing she did. It was something her brothers did. Because she had the same last name, she was a target. How many other of our citizens have been targets? How many other of our citizens have made mistakes? Oh, let's go back. How many of us have made mistakes? Have we been forgiven? So should we forgive others? It's not for us to judge. It's not for us to take anything away from anybody, any other human being that's going to be out here paying taxes and living like everyone else. It's time for us to give everyone the right to vote. See, I didn't tell you what I heard or what I thought. I told you what I've witnessed. Human beings crying because they finally are able to vote. Let's do the human thing and give everybody their right to vote back. Thank you for your time.
Thank you for being here. Is there anybody in the room who would like to speak in opposition? Are you in favor?
I'm in favor.
Okay, we had 2 minutes for 5 people, but we're going to go ahead and let you say a very, very brief
I'll be extremely
comment.
brief. There was nothing I could say could compare to the power of the testimony you've just heard. I'm Scott Price. I'm the policy director for the Alliance for a Progressive Virginia. On behalf of our membership, we'd very much like you to pass this amendment. Restricting the right to vote on the basis of criminal record is an archaic vestige of Jim Crow, and it's the 21st century. Let the people of Virginia vote on this.
Thank you. Is there anybody in the audience who would like to speak in opposition? Is there any member of the committee who has any questions of the patron or of the patrons? Is there any member of the committee who has any comments?
Second.
Can I just ask one quick question of the patrons? Included in this, in both, well, obviously include both of them, is it says that no person adjudicated to be mentally incompetent. And I know that is included in the piece about the felony. And I would just like to ask you about that question, because that is something that gives me pause. I don't know if anybody else has a comment or a question about that. Claire, you want to speak to that? Mm-hmm.
The reason why this is written to guarantee the right to vote to everyone is because that provision and the way it's written is quite arcane in terms of the way it interacts with the reality of people with developmental and other disabilities today. And yes, it is a fact that in an individual case, it might be appropriate to say that somebody doesn't have the capacity to participate in the process, but that should be an individualized decision and not a constitutional one. And so it is crafted to say everybody has the right to vote it can't be abridged by law. And the reality is there's quite a difference when somebody's adjudicated incompetent. Most of the time it has to do with their ability to manage their own affairs financially or otherwise. And that doesn't tell you much about whether they can or can't vote or can't vote responsibly or understand the right to vote. I have a brother who's an autistic savant. I could probably get him determined to be, quote, legally incompetent, but he votes every year and he totally understands the process and why he's voting and who he's voting for. So it really is an arcane provision, dates back to the way we thought about people with developmental disabilities and mental illness in the past, and needs to be taken out so that those issues can be resolved individually and not constitutionally.
I have a follow-up question.
Okay, thank you. Senator Edwards.
Yeah, because I thought this, does the Constitution, the way this is written, allow individualized determination if somebody is simply not competent to vote for whatever reason?
It wouldn't be a constitutional question, Madam Chair and Senator Edwards. It wouldn't be a constitutional question. It would be a question as to whether that individual person, in the same way they might be judged incompetent to other things, potentially individually could be judged to be incompetent.
Well, Madam Chair, the way
Senator
it's
Edwards.
written, would that prevent states from ruling that somebody is not competent?
No, Madam Chair and Senator Edwards, no. In fact, it would free the General Assembly to look at this and decide whether there needed to be some specific statutory provision to deal with your concerns. But it would deconstitutionalize this as a completely across-the-board thing in a time when we now recognize that not everybody with a disability is the same, and not everybody even with the same disability has identical abilities and disabilities.
Madam, one follow-up.
Senator Edwards.
I gather you're saying that judges could still rule if somebody's not competent for whatever reason, needs a guardian or whatever. Would that, the way this is written though, could a person still vote?
Madam Chair and Senator Edwards, that would be, again, taking this out of the Constitution frees the General Assembly to make individual policy decisions. If you decided a statute were necessary to look at this, and you could craft a statute that didn't abridge the right by law, but rather abridged it in a circumstance and situation in which it would be part of a competency determination, I think you could do that. But I think what we're trying to do with taking out of the Constitution is to make it clear that this is not a decision that you can apply constitutionally to every person who has a certain definition of disability.
So
Or ability.
to follow up, a judge could say somebody has a disability, and I guess by definition, if they're incompetent, they wouldn't be able to vote either, like they wouldn't be able to sign a contract.
Madam Chair and
that
Senator
analogy?
Edwards, I think the answer to that is yes, in the circumstance of situation that you're positing. But just like when you go to seek legal guardianship today, you have to sort of say, for what? For the financial affairs of the person, for these different things. And you would obviously have to make the case that the person's disability was so profound that they also would not be competent to vote.
But if I may follow up on that question, to his question, once you change this and repeal this language, then it would be irrelevant if somebody was adjudicated mentally incompetent. It would no longer apply to this specific question of qualification to vote. To his question, it's no longer an issue. Whether a judge rules that you're adjudicates you mentally incompetent or not is now no longer relevant for this question of qualification to vote or not unless or until the General Assembly steps in and passes something on its own. Anybody then can vote.
Madam Chair, just as the Constitution doesn't have a constitutional definition of who can make a contract,
right,
or who can be held accountable for their actions financially or otherwise, the Constitution change would only say the Constitution no longer determines that. It doesn't say what happens in an individual case after that. So what it does do is take the discriminatory stereotype out of the Constitution and return this where it should be in today's world, to an individualized decision in every circumstance. In the same way it would be an individualized decision whether somebody had the capacity to contract or make their own medical decisions or any of the other things that we say need to be determined on an individual case-by-case basis.
Okay, Senator Reeves.
So Claire, I'm a simple guy just trying to read this thing out, and I know it doesn't have anything about how we validate that we are 18 years old, living where we're supposed to live, or stationed overseas and all that stuff. We have gone through this committee on voter ID laws and everything else to the nth degree. How does this affect it with that one word, sole qualification? Will that make voter ID null and void? What does that do to the requirements that we've worked on to try to figure out what an ID is and who gets it and all that stuff? I'm just curious.
I think, Madam Chairman and Senator Reeves, I think it makes clear that you can't establish any new qualifications for voting. And it says if somebody's 18 and a citizen of the United States, a resident of Virginia and registered, that they have a right to vote that cannot be abridged by law.
So you're saying that would make voter ID laws null and void?
I'm not saying that it would automatically make them null and void, but it would not allow them to be a qualification for voting.
Okay.
An independent qualification for voting.
Right. Okay, are there any other members of the committee who have any questions? Is there any other discussion? Do we have a motion?
Move to report.
Okay, the motion's been made and seconded. Okay, there's a substitute motion to pass by indefinitely. That motion has been made and seconded. All in favor of passing the bill by indefinitely, please vote aye.
Ayes 8, no 6.
Okay, bill's passed by indefinitely. Okay, next on the docket is, okay, we have Senator Ubben and Senator Chase. Do you care who goes first? Senator Chase will have you go first. Oh, wait, sorry, Senator Ubben, you're already on your feet. Go ahead. Be quick. Is that okay with you, Senator Chase? He seemed to have had a disproportionate amount of time, so we'll give you a whole lot of time. He's gonna go. Do they need to go? Do your people need to go? Yeah. Okay.
I think we've got the same bill.
Bless you.
Right, on the governor's term of office? No, yours. Do you have Senate Bill 252, Senator Chase, on the governor's term of office?
No.
Oh, that's about the term he has to live in the state. Okay. So This is Senate Joint Resolution 250, constitutional amendment to allow the governor to serve 2 consecutive terms. And as the committee knows, and has heard before, the Commonwealth is the only state in the country that prohibits a governor from serving 2 consecutive terms. And there are some negative impacts on this, in my opinion. One of them is that the Commonwealth suffers from a lack of continuity. By the time a governor is settled, their agency heads are not all appointed until sometimes as long as a year. They have goals that they want to, initiatives that they want to further that are often not easily followed to fruition within 4 years. They should be accountable to the people. If a governor chooses to seek re-election, which most governors seem to do in other states, the voters should have the ability to decide whether or not they've adhered to their campaign promises to the extent that they would like to vote for them again or not. As you know, the Virginia governor signs a biennial budget, and that when a governor is elected, their first session, at minimum, they have to live with the 2-year budget proposed by the preceding governor. If a governor serves 2 consecutive terms, they would have more of their own budgets, their own 2-year budgets. Further, we lose a lot of experience. We know that we would never expect Microsoft or Disney to fire their CEO every 4 years without a performance evaluation, and that this experience is recognized by the General Assembly. We tend to elect longer-term legislators for leadership positions and consult for seasoned advice in some cases or others on how legislative process can work. So with that, that's the nexus of the nub of the bill. Former Governor Gilmore had said, agreed when he said the term limits hamper government planning, and that's what this is about.
Okay. Is there anybody in the audience who wishes to speak in favor of the bill? Don't everybody charge up at once? Okay. Is there anybody who wishes to speak in opposition to the bill? Okay.
Second.
Okay. Well, wait, quick. Is there any discussion from the committee? Okay. Motion has been made and seconded to report the bill. All in favor of reporting the bill, please vote on your screen.
Ayes 8, no 6.
I thank the members of the committee.
Okay, the bill reports. Okay. Senator Chase. Not really, but.
Good for you. Yeah. You got one through, I got none through. Yeah. Since the next.
No way. Welcome, Senator
Thank you.
Chase. You have waited a long time. I'm sorry.
Thank you very much. I'm going to be presenting SJ 252. This is, I guess, again, a constitutional amendment. You've seen this one before, a couple years in a row. This has to do with qualifications of the governor and the lieutenant governor and a residency requirement. And really, the gist of this, we're increasing from 5 to 8 years the number of years a person must have been a resident of and registered voter in the Commonwealth in order to be eligible to the office of the governor and also lieutenant governor. And really the whole purpose of this is to ensure, as many of our other states have done, is just increased, right now it's at 5 years, we're raising that to 8 years, to make sure that whoever is our governor is completely vested in Virginia. And so that is, honest to God, the
Madam
reason
Chair.
I introduced this bill.
Senator Deeds.
When has this ever been a problem? I mean, has there recently or within the last 50 years, 60, 70 years, 80 years, 100 years, been a governor who was here, lived here
In
as
other
short as
states.
5 years?
In other states, if you
Okay.
look at other states, that has happened.
But it's not happened here?
Not yet, but it could happen. It is a possibility. I'm just trying to be proactive. I want a Virginian. I want somebody that's fully vested with Virginia, and I'm not specifically thinking of a target. I want Virginians to govern Virginia.
Madam Chair?
Senator Edwards.
Yeah, shouldn't that be a decision of the voters? If somebody just parachutes into Virginia and wants to run, we think that's great. Like Romney just moved back to Utah and got elected to the U.S. Senate. It happens in other states. People move, and then all of a sudden, like John McCain, he first ran for Congress, didn't run for governor. But remember, the comment was, "You haven't lived for very long, have you?" Well, I moved around a lot. The only place I lived any longer was in Hanoi Hilton.
Sure. I guess I took a look at what the other states, kind of the averages there, and I just thought ours was a little bit lower. And I'm a Virginian. I've lived here since 1979, and I do look at what other states do, and I think it's important
Well, how about
that
this?
we have a Virginian, and so that's why I introduced the bill. Thank you.
Madam Chair, suppose, and I was gone for a while in the military and other places, but suppose I just came back from 20 years in the Marines, and I grew up here, went to college here, went to everything here, but I was gone for 20 years. And I came back, and the next year I wanted to run for governor, and I was really, real qualified. Now here, you got to wait 5 years. Where'd you come up with 8? I mean, why any time, really? If people move around a lot in this day and age, it's not unusual for people to live in a lot of different places.
Well, I think that's a valid question, and I would never want to do anything that would disenfranchise our military. And we could talk about an amendment to that if there's something you'd like to propose regarding our military. What I would say to you, the reason I chose 8 years, it allows, as Senator Eben mentioned, with having 8 years for 2 terms of a governor. I voted for that bill because I support the consistency of having 8 years, someone that has lived through 2 governorships, has been here through 2 full governors, has a vested interest in Virginia, and it just made sense to me. So I appreciate the questions. I think they're valid questions. If you're concerned about the military, I'm open to any amendments that you might suggest.
That's just an example, yeah.
Sure. It really was not meant to be I'm not trying to pull any fast ones over here, in other words.
Does anybody else have any questions or any comments? Oh, okay.
Thank you, Madam Chair.
Senator Chafin.
Yes, I've got a question, Senator. Is it your understanding that Tennessee has a 7-year, the states that surround us, Tennessee has a 7-year requirement, Kentucky has a 6-year requirement. Is that your understanding?
That is correct.
Thank you.
Okay. Is there a motion? Any further discussion?
Move to report. Second.
Okay, the motion's been made and seconded to report SJ 252. All in favor, please vote on your screen. Aye.
I can vote for myself. Thank you.
Ayes 5, noes 8, abstentions 1.
Okay, Bill fails to report.
Thank you. Would you like to hear SJ 253?
Yep.
Next, okay. This, once again, is a constitutional amendment regarding term limits. When I ran for office almost 4 years ago, one of the things that I ran on was term limits. The folks in my district that I spoke to said, listen, we're tired of career politicians. Now that I've gotten to know all of you all, I understand how much hard work, and I know that there's some validity to have some type of institutional knowledge. And so I looked again at what other states were doing. In Florida, we saw the issues of having too short of a term limit. So I'm not targeting any of my fellow colleagues, so I just want to make sure we're clear on that. But I do think it's important that we continue to remain a citizen legislature. We are incumbents. We do have some built-in internal incumbency where it would be difficult for someone that's running for the first time to run against us, name recognition, donor support from PACs, those types of things. And so I think that we should continue to encourage grassroots candidates to run for office. And so that's my purpose for introducing this bill. And I think that, if you talk to the folks in your district, a lot of them, they don't trust government, they don't trust politicians, and they would like to see more frequent turnover. And it prevents corruption, increased accountability. The bill allows for 12 years in each the Virginia House of Delegates and the Virginia Senate, which applies to consecutive or non-consecutive terms, but the maximum is 24 years. So that's still a good period of time. I listened to what people were saying about concerns with losing too much institutional knowledge. So we want to ensure that our elected officials run our legislature, not the unelected bureaucracy. And I've heard your comments and concerns year after year, and so I've made sure that we've taken that into account, that sees elected leaders come and go. But this is what happened in states like Florida where the term limit is too short. We do not want to empower or embolden the bureaucracy of each body and allow our legislature to be run by unelected officials, and I get that. But at the same time, we must ensure that legislators have reasonable term limits. Other states who have implemented term limits include Florida, Louisiana, Missouri, and 12 other states, which I won't read through the list for sake of time. And for that reason, I ask that you pass the bill.
Madam Chair?
Senator Edwards.
The concern I have with term limits is just the fact that the bureaucracy is going to run the legislature. Without institutional knowledge in the legislature, we're very part-time, and it's awfully hard to kind of stand up to the bureaucracy, because unless you have better knowledge, and because they always have more information. And so you need people with institutional knowledge, in my opinion, to make the system work well, especially since we're only part-time to begin with. California's, but with all the term limits they have, has made itself virtually ungovernable. It's a mess. They need to throw out the Constitution and come back and start all over again. And I think they regret having term limits. It's interesting to hear in Florida, they think they're too short. Well, there are other states, too, that have similar problems. So I'm opposed to term limits. Every time you run, the citizens are entitled to make a choice. They like you. They think you're doing a good job. Maybe they want you to continue. If not, they'll put somebody else in.
I appreciate your comments. Thank you.
Madam Chair.
Who is that?
Thank you.
Go ahead.
Senator Chase, I would just say for our friends in the House of Delegates who face re-election every 2 years, that they should have a higher term limit than we do. And I would ask if you would consider amending theirs to 16 years in the House. I mean, they face the voters every 2 years, and we only got to run 3 times to get 12 years in. So I think at least the House of Delegates should get more than we do. That's terrible. I ask if you'd amend theirs to 16 years for the House.
I'd be happy if there was consensus to amend my bill, if there were others that would support that.
So, Senator Chase, is that a friendly amendment?
Well, I don't know if it is.
Are you trying to amend her bill?
Yeah, yes, I've asked if she'd amend it to
If there would be
16
other
years.
people that would support, I'd be willing to amend.
Well, I don't think I can do a involuntary or a
Yeah.
impromptu poll of the committee. So that's either a friendly amendment, or you want to accept that amendment as a friendly amendment?
Yeah.
Mark, or Senator Peake, are you presenting that as a friendly amendment?
I'll just withdraw that, and we'll see what happens on the vote.
Okay.
Okay. Thank you. Thank you, Senator
Okay.
Peake.
Does any other member have a question for Senator Chase on her bill? Would anybody like to speak to this bill from the audience? Okay, with that, the bill is properly before the committee. Hobie, will you please call the roll? What? Oh, I'm sorry. I thought we were already halfway there. I'm sorry. I came into it half-cocked. The committee will entertain a motion on the bill. I'll move to report. Is there a second? Ferris Bueller here? Okay, there is a motion to report and second the bill. The committee will now vote.
Oh, I get to do yes. Forget about that.
Okay. The nays are 11, the yeas are 3. Senator Chase, you have one more bill?
Yes, I do. And I know this is going to be one you're all going to want to say yes to. This is a little different bill than what y'all have seen before. SJ 258 is once again a constitutional amendment that has to do with political reform, which we've all been talking about at a micro level. This is a macro level bill that we can, in my opinion, that we can all agree on. And basically what the language says is that the General Assembly shall regulate the role of money in elections and governance to ensure transparency, to prevent corruption, and to protect against the buying of access to or influence over elected officials. No reasonable regulation of the role of money in elections and governance shall be deemed a violation of the freedom of speech provided by for this Constitution. And the second part of that is that no electoral district shall be established that intentionally favors or disfavors any political party.
Mr. Chair.
Senator Deach.
It was my understanding that the Supreme Court of the United States said that campaign contributions, campaign money is protected by the First Amendment.
That is my understanding as well.
The United States Constitution.
Correct.
How does this override that?
So what we're trying to do is allow the people to speak and challenge that decision.
But how would that
Senator Deach.
override the First Amendment of the U.S. Constitution?
So in that court case, they were saying that anytime you donate money to a campaign, so if I'm a corporation and I'm outside the state of Virginia, currently, they can donate. Because what that court case, as you mentioned, advises is that by donating that money represents free speech, and that's protected. And so what this does is it challenges that. And it says the people don't want to accept that. The people are tired, Virginians, and I'm going to go back to being a Virginian here, are tired of outside campaign funds coming into Virginia politics and affecting their elections. But what it does, it doesn't manage that at a micro level. Like we're able to introduce bills at any time to discuss a lot of these micro level things. What I'm talking about is a macro level insertion into our Constitution that would say that money is not allowed from outside sources to influence our elections. It's to ensure transparency, prevent corruptions. All these initiatives that the governor has introduced and put forward would fall as a subset under this.
Mr. Chair.
Senator Deach.
I share what you're trying, I share your view and what you're trying to do with respect to money. My concern is that this just, because of the Supreme Court ruling, this just is not going to effectively touch it. I don't think we can preempt the U.S. Constitution.
I understand, and I'm all for challenging decisions. Like we've done, every single Constitution amendment today has done the very exact same thing. We are challenging the current status quo, when I agree with that, but I'm willing to do that. It's interesting, this actually passed in New Mexico, and they're actually moving this in New Hampshire, Ohio, Colorado, and Virginia. And this is what legislators say that they agree with, that they entered public service to improve the lives of the people we represent and to make Virginia and the United States better. There's broad bipartisan support for fair elections. I mean, we all support that, and governance in the state of Virginia and across the United States. We agree on the underlying principles that money in elections and governance should be transparent. I think we all agree on these things
Can I ask
broadly.
Mr. Chair?
Senator Deach.
Is this part of the Constitution in New Mexico now, or is it just passed?
Yes.
It is?
It is now.
And in the other states, it's being taken up?
Yes.
Okay.
That is correct. Absolutely. And I would also like to give a special note to two guests that we brought in, featured on the cover of Inc. magazine, and above the fold of the Wall Street Journal for creating the hottest business in America. Steve Lipscomb is here, and I actually ask him to rise right now. Has founded and run both public and private American companies. He's currently managing director of Fix It America, which first introduced this idea to me, which works to pass the Fix It constitutional amendment in states and at the federal level. And with bipartisan sponsorship, the amendment passed in New Mexico in 2018 and is currently moving forward in Ohio, New Hampshire, Colorado, and Virginia this legislative session through my efforts. And I would also note that he has actually brought from the past Thomas Jefferson, who has been sitting quietly on the front row and has flown in just to show support of this legislation. So thank you, Thomas Jefferson. Thank you. Thank you very much. Would you, if it pleases the chairman, would there be an opportunity for Steve Lipscomb and Thomas Jefferson just to offer their brief comments about their efforts and answer any questions that you all may have about passing this legislation in New Mexico?
Absolutely.
Thank you.
We'll give
Steve
them
Lipscomb. Thank you.
5 minutes each. Reasonable? Get out
Mr.
of here.
Chairman, I don't know how much Thomas Jefferson's going to have to say about this.
I wish he would have spoken up on the ERA bill so we could get the real details on it
That
from
would have
100 years
been
ago, right?
helpful. What I may want to do is, Mr. Chairman, Senator Reeds, maybe address the notion of how an amendment to the Virginia state constitution fits in the context of Buckley Vallejo and other Supreme Court cases. This specifically, if you look at the language, only addresses the freedom of speech rights in the Virginia state constitution. What that means is it doesn't run afoul of any of the current precedent. In fact, what it does is helps Virginia do what it does best, which is lead and move forward. So if you'll see, it's only talking about in this constitution, meaning Virginia.
So could,
Mr. Chair.
1 second, Senator Dees, because I have a question for him as well. So are you aware of any pending legislation under the Supreme Court right now that has to deal specifically with this?
So the current precedent, this has to do only with the First Amendment speech rights in the Virginia state constitution. What the Supreme Court said about the U.S. Constitution absolutely stands. But the notion is that within the confines of what that precedent is, you get a chance to, in the founding document of the state of Virginia, put these principles, the core principles, like freedom of speech. You know how much money affects elections and governance because you have to deal with it every day. This is a chance for those core principles that we agree all across the aisles to actually be in the
Right, but my question is there pending litigation at the Supreme Court that deals specifically with this?
Not that I am aware of at all.
And I would
You
look
mean
to
this
my dais.
particular language?
I don't know, but my question is, isn't a state candidate for office protected by the U.S. Constitution too? And how can this effectively preempt a federal constitutional right that a candidate has to?
And again, I don't want to contradict the answer, but the understanding is that it doesn't. In other words, absolutely the preemption exists, and the current precedent of the Supreme Court of the United States is not changed at all. On the other hand, to empower you as much as you possibly can, and to state a mandate for this basic principle, we believe that money and how it works with elections and governance ought to be transparent, ought to prevent corruption, and ought to guard against the buying of access to undue influence over representatives. That simple piece allows you to do that up to the level of what's restricted at the national level, and we're working right now at the national level. So state by state, we're working to have this happen and work with Congress in order to have the longer, as you know, lengthy process of a constitutional amendment that needs to be ratified.
Mr. Cummings, Mr. Chairman.
Senator Edwards.
Can't we already do this? Pass legislation about limiting campaign contributions and all? We could do that if we want to, right now.
Madam Chair and Senator Edwards, without a doubt, you can, within the confines of the precedent, do that now. What we're working on in a national effort is to try to agree that money and the way it interacts with our democracy is critical enough to be one of those things that the founders were smart enough to know they wouldn't know everything that was going to become this important. But the way it affects your daily lives and the way it affects every election cycle is something that we believe all the people who are working on this, 11 organizations, that we believe you ought to be empowered to do this. If I could wave my arms and Buckley Viva Leo would go away, that would be great. But to empower you as much as you can to inculcate those principles and help us get Congress to do the same, that's what we're working on.
Mr. Chairman, my point is we're already empowered. Have you proposed a bill, a legislation to say no more than $5,000 per person or corporation to any candidate, or corporate funds are not allowed, such as at the federal level? I mean, our laws are very loose. Has anybody put in a bill to do that? Because we're fully empowered to do whatever we want to do.
Right. I think the intention of this is to keep it very broad, to find agreement. A lot of times legislators can find agreement on broad issues, which is, this is trying to do, saying we agree on these issues. How we do that at the granular level is how you said that we could introduce individual pieces of specific legislation. But you know, in this room, we have very different agreements and perceptions on that. So this is just simply trying to find a baseline of agreement from which we can work. And saying we want this in our Constitution on behalf of the people, and actually involving the people in that process. Let the people vote on it. I think it would, you know, we were talking about the ERA amendment and how just the discussion of it gave women more opportunities. I think just the discussion and having this in the forefront, in the media and the news on the forefront, and getting this before the people to vote on, let them be the ones to vote on this. We just vote on the regular bills that come up before us, and that doesn't really involve the people. But when you have to put a constitutional amendment on a ballot that the people vote on, I think they're more inclined to educate and inform themselves and feel included in that process.
Okay.
Thank you.
Yeah. Thank you, Senator Chase. Is there any other? Senator Vogel, Madam Chair.
I was just going to make an observation that we had talked about, and this is obviously something that just happened, but the Supreme Court just recently agreed to take cases that deal with the political piece when it comes to
That's true.
political consideration.
That's right.
And that is the first time ever that the court has agreed to do that. And now with a new member of the court, I would be very reluctant to actually move this while we're waiting for the court to opine. But anyway, I just wanted to make that observation and mention that to those on this committee who follow the court and the court's decisions and some of this redistricting litigation very closely. Thank you.
Thank you, Senator Vogel. So while I'm vice chair of this, I am chair of Social Service and Rehab. And Senator Chase, I would tell you in that committee, we don't pass bills that when there's pending litigation that's ongoing, we typically don't pass bills out of Social Service and Rehab that would conflict with pending litigation to either give one party to that litigation upper advantage or disadvantage to that point. So I'd just say that to the committee, on this committee. It's not my committee. It belongs actually to Senator Vogel, and I don't know how we typically go in here, but I would just lay that out there. That was my previous question of why, because I thought I remember hearing it or reading it or something, and I don't want to go run contrary to what we typically do for committee structure. So with that, is there anyone else that wishes to testify on the bill?
Sure.
Yes, sir.
No, I thought you were specifically asking about the money and elections and governance piece. I was in the oral argument when it was last considered, and truth be told, a number of times the Supreme Court has taken cert for cases to talk about redistricting. The latest effort, they punted again. There are two cases, as I understand it, that they have currently now decided to take before them to look at this again, one of them being in North Carolina. So, I mean, again, I don't know what the protocol is for the committee, but I would say that over time, it's been very clear from exactly what Justice Kennedy and others have said that they believe this is a huge problem, and they certainly wish Congress would do something about it. But they're not sure that they have the ability to do something about it. The case in North Carolina is interesting because the legislature specifically said we politically gerrymandered. We did it on purpose. The head of the House stood up on videotape and said that that was what they did because that's how they were advised by their attorneys to do it. So I would say that this is a long-standing piece, and the Commonwealth of Virginia has, I believe, the opportunity to lead in these two places of pro-democracy that people all over the country are saying at 80+% levels, we care about this. It should be fundamental to our democracy.
Thank you very much. Any other members of the committee wish to comment or questions? Okay. With that, the committee operates on motions. Do I hear a motion to report? Okay, I don't see a motion to report your bill, so Senator Chase, that bill will be PBI'd. So is there a, do we need to kill it, or is there, okay, do I have a motion to pass by indefinitely the bill? I have a motion, it's been seconded. Any discussion? Seeing no discussion, committee will vote to PBI.
Thank you.
Senator Chase, thank you. With that, I believe, Meg, are we done with the docket? Okay. Let me just thank everybody who came out today, and thanks Senator Vogel. I know she's been a little ill lately for sitting through this whole thing, and with that, the committee will rise. Thank you.